A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam and Company. My name is Cam Edwards. It is good to have you with us today. Although I do wish that the news that we were reporting on was better today. For weeks, we have been watching the U.S. Supreme Court to meet in conference. They have had about a dozen or so Second Amendment cases that they have been considering. And the expectations were that the court was going to take one of them. We saw earlier this spring, after the New York State Rifle and Pistol Association versus New York City lawsuit was mooted by the Supreme Court after New York City changed the law in question, we had four justices that had come out and said, listen, it is time to take a Second Amendment case. We had Justice Gorsuch, we had Justice Thomas, we had Justice Alito, we had Justice Kavanaugh. And it takes four justices to hear a case. So the expectation was one of the almost dozen cases, whether it was a case dealing with the right to carry, a case dealing with quote-unquote assault weapons bans, maybe a challenge to California's microstamping law, that one or more of those cases would ultimately be granted cert by the Supreme Court. They would hear one of these cases. Well, today, the orders from last week's conference came out, and virtually every one of those Second Amendment decisions, virtually every one of those cases that was under consideration by the court, save for one, was denied cert, meaning that there were not four justices voting to take this case. Now, that doesn't mean, by the way, that Justice Gorsuch or Justice Kavanaugh or Justice Alito or Justice Thomas changed their mind, but it does mean that there apparently, at the very least, was concern about whether or not there would be a fifth vote to join those four justices in striking down one or more of these gun control laws. So let's take a look at the challenges in question. Then we're going to talk with Amy Swear of the Heritage Foundation. Alan Gottlieb of the Second Amendment Foundation is going to join me as well a little bit later on in the program with his reaction to the court's decisions today. But these are the cases that the court rejected today. Pena versus Haran, which is a challenge to California's microstamping law that took effect back in 2012. Because of the microstamping law, not only have no new models of handguns been made available for sale in the state of California, but existing models have dropped off of the roster of handguns certified for sale in the state of California. If there's a minor design change, if a screw gets moved, a half an inch to the right in the design of that gun, Cal DOJ considers that to be a new handgun model, and all of a sudden, that model is no longer available for sale in the state of California. The Ninth Circuit actually upheld this law, even though it acknowledged, there doesn't really appear to be a way for manufacturers to comply with the microstamping standard, which requires two areas in the firearm itself to stamp a unique code on the cartridge of every round of ammunition that's fired from a semi-automatic handgun. The state of California can't explain how manufacturers are supposed to do this. Manufacturers can't figure out how they're supposed to do it. But the Ninth Circuit says, even though it's impossible to comply with the law, that doesn't mean that the law is unconstitutional. And the Supreme Court, again, refusing to grant cert to this case today. You also had Gould versus Lipson, which is a challenge to the carry laws in Massachusetts. Warman versus Healy, which is a challenge to Massachusetts' quote-unquote assault weapons ban. Rogers versus Grewal, Cheeseman versus Palillo, and Schillick versus New Jersey, all dealing with challenges to New Jersey's May issue concealed carry law, in which you have to show good cause or actually justifiable need in order to receive a concealed carry license. Very few people in New Jersey actually meet that bar, meaning that the average resident of New Jersey cannot exercise their right to bear arms. Malpaso versus Palazzi was a challenge to the state of Maryland's concealed carry requirements, which again, very similar to New Jersey's. There was also Culp versus Raoul that challenged an Illinois law barring residents from 45 other states from applying for a non-resident concealed carry license. Wilson versus Cook County took on Cook County's ban on modern sporting rifles. Mance versus Barr, a case challenging the ban on the interstate sales of handguns. Now, Justice Clarence Thomas did offer a written dissent in the Rogers case. He was joined by Justice Brett Kavanaugh, arguing that the court really did need to hear this case that, again, it has been far too long since the court has actually taken and ruled on a Second Amendment case, and lower courts are abusing what the court said in Heller and McDonald. He said, quote, "It appears that a handful of states throughout the country prohibit citizens from carrying arms in public unless they can establish, quote, good cause or a justifiable need for doing so. The majority of states," he writes, "while regulating the carrying of arms to varying degree, have not imposed such a restriction, which amounts to a ban on the ability of most citizens to exercise an enumerated right. The courts of appeals are squarely divided on the constitutionality of these onerous justifiable need or good cause restrictions. The D.C. Circuit has held that a law limiting public carry to those with a good reason to fear injury to their person or property violates the Second Amendment. By contrast," Justice Thomas wrote, "the First, the Second, Third, and Fourth Circuits have upheld the constitutionality of licensing schemes with, quote, justifiable need or good reason requirements, applying what purported to be an intermediate scrutiny standard. The question whether a state can effectively ban most citizens from exercising their fundamental right to bear arms surely qualifies as an important matter on which the courts of appeals are in conflict. We should settle the conflict among the lower courts so that the fundamental protections set forth in our Constitution are applied equally to all citizens." Well, again, that won't happen today as a result of the court's decision. Joining me to talk about this, Amy Swear of the Heritage Foundation, who covers all kinds of legal issues for Heritage, including Second Amendment cases. Had the opportunity to speak with Amy shortly after the court announced that it would not be taking any of the Second Amendment cases that we just mentioned. Take a look and listen to Amy's response. Amy, thank you so much for coming on the program today.
Thank you for having me.
Absolutely. The Supreme Court had this smorgasbord of Second Amendment cases laid out to take. They could take a right to carry case if they wanted. They could nosh on a micro-stamping challenge. They could take on an assault weapons ban. Instead, the court today rejected every single one of the Second Amendment cases that's been pending. What happened?
Yeah, that is a good question. I think it's a bit surprising given that the court just took up the New York pistol and rifle case this past term and then got rid of it without doing anything with it. So it seems a bit surprising that given the vast array of Second Amendment cases, and not just like in terms of issues, but in terms of fact patterns, they had their choice of various different fact patterns of, whether they wanted to go after, Maryland law or New Jersey law. They had so many choices and they just didn't take any of them. So it is a bit surprising. I think for many of us, a bit heart-wrenching. It hurts a bit. I think the good thing to keep in mind here is there's still a lot of time and still a bit of an empty docket for this upcoming term. So there are still more cases, more petitions that can be filed. The court certainly still has time to take and consider a Second Amendment case. But again, given that it had such a vast array of options, to see all of those now off the table is a bit disheartening.
Absolutely. Particularly given the statements that we saw in the wake of the New York State Rifle and Pistol Association case, the case that the Supreme Court ultimately declared was moot because New York City and New York State had changed the law that was being challenged. You had, after that decision, you had four justices either on paper or, through what they had said during oral arguments, that it was time for the court to take a Second Amendment case. You need four justices to hear a case. You need five, obviously, to get a majority. Does this indicate that those four justices were either convinced that they did not have five votes to strike down some of these gun control laws, or is it still an open question about Justice Roberts? I think clearly now there's a lot of questions about, where is Chief Justice John Roberts when it comes to these issues? He sided with the majority in Heller and McDonald, but he did argue to moot the New York City case. Is that one of the big questions that you have right now? Where is Justice Roberts on the Second Amendment?
Yeah, so I think the question is less, whether the other four think that he is hostile to the Second Amendment here. I think it's probably, if I were a betting person, I think it's probably more along the lines of he either hasn't tipped his hand either way, or there's some sort of, in the background, he's hoping for a different time, essentially telling them, look, Chief Justice Roberts is very historically concerned with political ramifications. So he may just be waiting for a better what he would consider a better political opportunity, possibly post next election. So that is one consideration, is that he is on board, but he's waiting for something he considers a better opportunity. It would be difficult for me, given what we've seen. I mean, he joined Heller and McDonald and Caetano without any sort of reservation whatsoever. So it would seem to be a bit of a stretch to suggest, he wouldn't, at least at the end of the day, side with the other four conservative justices. So it is unclear sort of what in particular is causing this hesitation, but it is pretty clear at this point that he is sort of the one unknown left.
Absolutely. And I suppose that there's also the chance that the justices just simply couldn't agree on which case to take, and therefore you didn't have 4 votes to take any of them. But as you talk about the facts in all of these various cases, I mean, you've got circuit splits, for example, when it comes to the issue of the right to carry. And you've got some circuits that say, yep, there is a right. You've got other circuits that say, no, there's not a right. That, to me, that's the ideal situation for the court to step in. I mean, I think, every one of these cases, I think, was incredibly important. I'm bitterly disappointed that the microstamping law is not going to be heard by the U.S. Supreme Court. But, some of these challenges to the carry laws around the country, to me, that seemed like as close to a Supreme Court slam dunk as you could possibly find.
Yeah, again, given the vast array of cases that they just had so many options to choose from. And I think you're right. For a while, there was this argument of, there's not really a circuit split on some of these cases. But it has since come about that there are very serious circuit splits, at least insofar as concealed carry and good cause laws are concerned. So we know that there's a circuit split. And even beyond that, what we're also seeing is a very serious deprivation of Second Amendment rights in some of these states, which in and of itself should be enough to compel the court to take on these cases. So again, it's disheartening and a bit disconcerting that they haven't done so here.
What do you think this does for the 2020 elections in terms of the importance of the Supreme Court? Obviously, there's been a lot of talk about the work that President Trump has done in terms of getting judges appointed to the bench, getting them confirmed by the Senate. It seems to me like this just ramps up the importance now of talking about the impact of the presidential election on our judiciary in the years to come.
No, absolutely. I mean, we're at a crossroads here, especially with things like the Second Amendment, where you have 4 justices who appear very keen on taking a case, and having that 5th justice, having a 5th vote that is very sure becomes very, very important in these cases. And when you're dealing with a new president who's going to have 4 years, given just the demographics of the Supreme Court right now, we have a number of older justices where that could be a deciding factor. So this is, for better or worse, the reality of the Supreme Court right now is that there is 5 votes that are going to be the arbiter of some of our very important constitutional rights. And so you're right, given how we appoint and confirm judges, this is a very, very important issue.
Last question for you, Amy. I mean, given what the Supreme Court did today, do you believe that this will embolden gun control advocates around the country? For years now, it's been gun control advocates that were afraid to let a case get to the Supreme Court. We saw New York City change its law in order for the Supreme Court to avoid review. But they've got to be feeling pretty emboldened right now, watching all of these Second Amendment cases be denied by the court today.
Oh, absolutely. I mean, because not only now do you not have the anticipation of a ruling that is going to strike down some of these laws, you have the court once again telling the nation, it's been 10 years since we've took a meaningful Second Amendment case. It's not that important. It can wait a little longer. And so I think you're right in saying that's going to embolden gun control advocates to say, look, we can pass these laws. The Supreme Court isn't going to do anything about it. There's nothing to really stop us. And so I think that's going to play into their hand there.
Now, listen, Amy, again, I appreciate you coming on the program. I so wish that it was better news. I mean, just a little more than a month ago, I think you and I were talking about some of the cases that the court was considering, and we felt really optimistic that the court was going to take at least one of these cases, if not more. But again, I appreciate your analysis and your insight, and hopefully we've got better days ahead for us.
Yeah. One of these days, Cam, it's going to be you and me discussing, hopefully a Supreme Court victory here. So.
Knock on wood. Amy Swear from the Heritage Foundation, heritage.org. Thank you so much, Amy. I look forward to doing this again soon. Now, I also had the opportunity to sit down and spend a couple of minutes with Alan Gottlieb of the Second Amendment Foundation to get his reaction to the news out of the Supreme Court today. And Alan, too, Alan had some pretty harsh words for Chief Justice John Roberts. Take a look and a listen. Alan, thank you so much, sir, for coming on the program. I really appreciate your time today.
My pleasure, Cam.
Well, I can imagine your reaction to the news from the Supreme Court today, but why don't you go ahead and fill us in? What was your first immediate take when you saw that the Supreme Court had denied cert in all of these cases, all of these challenges dealing with gun control laws around the country?
Well, there is still one left, so they didn't do all of them, but I was in shock. The fact of the matter is that there was a number of cases covering a number of different, subject matters of Second Amendment rights that it had such a cafeteria, a plate to be able to choose from. To not be able to choose one of those cases is appalling, especially with the lower courts thumbing their noses at the Heller and McDonald decisions. I am really in shock. They held these cases a very long time. The fact that they held them this long indicated that there was a lot of interest in taking them. The fact that they didn't take them, to me, is appalling. And to me, it falls to the feet of Chief Justice John Roberts. I think he was the one who wouldn't commit to which way to go. And as a result, I think he owes an explanation to every gun owner in America.
It's interesting. You talk about the fact that a lot of these cases had been held. I mean, we've seen them being considered in conference ever since New York State Rifle and Pistol Association was mooted by the Supreme Court earlier this spring. Some of these cases, Alan, you're right. I mean, the court has actually been holding on to them for months and months and months. They have not denied cert. They haven't accepted these cases until today when they denied cert to so many of them. We'll get to the Rodriguez case in just a moment. But you're right. I mean, if this were simply an issue of, the votes aren't there for the court to take these cases, why would they have held on to the Rogers case out of New Jersey? Why would they have held on to the Pena case out of California and so many others just to simply say, no, we're not going to take any of them?
That's a great question. I don't have the answer to it. But the bottom line is that Chief Justice John Roberts obviously wouldn't commit to supporting one of those cases. And 4 judges on the court that really would want to hear it, it only takes 4 to hear it, that would have chosen to take a Second Amendment case were leery of having Roberts vote the wrong way. That's all I can come up with. I think he owes the public a very big explanation about this. I mean, this is an important area of constitutional and civil rights. It's an area that, it's been coming under modern law with Heller and McDonald being defined. There are significant problems right now in lower courts, with split decisions and thumbing their nose at those decisions. The fact that they won't deal with this and they put it off is not the way you deal with constitutional law.
Absolutely. Now, you mentioned that there is one case that the court did not take up today, the Rodriguez case. This is also out of California. Is that correct?
Yes, that's also a Second Amendment Foundation case. So we're the last man standing, I guess. The Rodriguez is a confiscation case where they took a woman's guns. They had no right to take them when you give them back, even though she's legally eligible to own firearms. And they basically said, well, if you want guns, go buy new ones, but we're not giving your old ones back. It's a sheer confiscation case. I'm hoping the court takes this one. Any case that they do take, they can define a lot of things that we need to find on Second Amendment rights. So hopefully this is the one maybe they're waiting for. But I think they need to give an explanation to the American people because this is not the way Supreme Court should operate.
How important, I asked this question of Amy Swear of the Heritage Foundation a little bit earlier, but I want to ask this to you as well. How important does this make the 2020 election? We've seen the work that President Trump has done in confirming judges to the lower courts around the country, to courts of appeals, and even with Justice Kavanaugh, who joined Justice Thomas in Justice Thomas's dissent of the decision not to take the Rogers case out of New Jersey today. How important is the election right now in terms of putting justices on the bench from top to bottom in our legal system that will recognize our right to keep and bear arms?
Obviously, very, very important. That's the elephant in the room, I guess. Maybe that's one of the reasons why the court chose not to deal with it, is they don't want to politicize the issue. Maybe the conservatives on the court want this to be an issue so that Trump gets reelected and gets to appoint more pro-gun rights judges. I don't know. It's the only explanation I can come up with that might make any sense. But there's no doubt that it makes the next election that much more important for us right now, because obviously in the next 4-year term there'll be 1 or 2 seats for sure turning over to the Supreme Court. And now it makes it all that much more important for Trump to get reelected.
Talking again with Alan Gottlieb of the Second Amendment Foundation. And you know, Alan, what does this do for your organization, for the Second Amendment Foundation? You are involved in, again, so many legal challenges around the country. I can't imagine that that's going to stop just because of the Supreme Court said today we're not interested or we're not going to take any of these cases that are before us at the moment.
No, we're not going to stop. In fact, the trial gives us impetus to keep going further and file more cases until we force the High Court's hand to make a national ruling and expand Second Amendment rights. So we're going to keep at it. We've got a lot of cases in the pipeline, climbing up the ladder. We're going to be there for a while, keep pushing at the Supreme Court until we get the rulings we need.
Well, Alan, again, thank you as always, sir, for the work that you do. Thank you for joining me on the program today. And hopefully the next time you and I have the chance to talk, it'll be better news that we're discussing.
I sure hope so, Cam. Thank you.
Thank you, sir. Alan Gottlieb with the Second Amendment Foundation joining us here on Bearing Arms, Cam and Company. Well, you know, as Alan said, the Second Amendment legal fight does not stop just because of the court's decision today. There are a number of other cases out there that are in the courts of appeals, including a challenge to Hawaii's open carry ban, the Young versus Hawaii case that's currently before the Ninth Circuit Court of Appeals that I think is also very interesting. But again, there were a number of good cases for the court to take, and they simply did not today. So I wish that I had confidence that in the future good cases are going to be accepted by the Supreme Court. But I have to say, with Alan and Amy, I'm right there with them. This was a bitter disappointment from the Supreme Court today, and again, we will have to wait and see what the future holds. But I do believe that this does make it even more critically important that the November elections turn out gun owners and voters who will put in place politicians and elected officials who will support the Second Amendment, who will nominate justices that recognize the plain language of the Second Amendment and the right of the people to keep and bear arms that shall not be infringed. Because, again, the stakes are high, not just for the next 4 years, but perhaps the next 40 years. Now, before we get to our good deed of the day, our recidivist report, and our armed citizen story, the Trump campaign has a special offer just for you. The president would like to meet you. This will be the first opportunity that President Trump has had to meet with American patriots like you since our country started reopening. His team will cover the flight, hotel, and give you VIP access for yourself and a guest. And President Trump will even take a picture with you. All you have to do is text ENGAGE to 88022 today for your chance to meet President Trump. Again, that is ENGAGE, ENGAGE, to 88022 to win this contest and join President Trump in the fight to keep America great for 4 more years. Now let's get to today's armed citizen story, our good deed of the day, our recidivist report. We will start there. Story out of Chicago, Illinois, where 2 are being held on $50,000 bail in the dragging of a Chicago police officer with a stolen car. Yeah, just $50,000 bail, by the way. That's not a lot of money. According to the Chicago Tribune, 21-year-old Darian Mitchell, 20-year-old Cordero Ramey, were each shot Friday after the encounter with police when they, again, allegedly tried to evade authorities. They dragged an officer from a reportedly stolen vehicle as they drove off. This all began as an auto theft investigation about 5 o'clock Friday. According to a police spokesman, Mitchell now facing 1 felony count of aggravated battery on a police officer, as well as 1 count of possession of 15 to 200 ecstasy or ecstasy analog pistols, as well, or pills rather, as well as 1 felony count of receiving or possessing a stolen vehicle. Ramey facing a felony count of attempted aggravated unlawful use of a weapon for not having a FOID card, as well as 1 felony count of receiving or possessing a stolen vehicle. Apparently, this all started around 7:15 Friday morning when Ramey allegedly climbed behind the wheel of an unattended 2018 Chevy Malibu and drove off while its two occupants were peeing in an alley before making a trip to a White Castle restaurant. About 10 hours later, an officer with the department's major auto theft investigation unit got some information from OnStar that the Malibu was there in the Chicago city limits. Officer drove to the scene, pulled in front of the Malibu while two officers in a marked car pulled behind it. Prosecutors said as the officers approached the driver's side door, Mitchell, quote, popped up from a reclining position. Officer then drew his weapon, ordered Mitchell to turn off the engine, get out of the car. Instead, Mitchell allegedly reversed towards one of the other two officers before driving forward, hitting the auto theft officer as he sped away. The officer became caught on the Malibu and was dragged as the vehicle made a U-turn. After completing the turn, the officer was freed and fell to the ground, but quickly had to roll out of the path of the fleeing car. One of the accompanying officers fired 5 shots at the vehicle, striking both Mitchell and Ramey, who was in the front passenger seat. According to the Chicago Tribune, Judge Susanna Ortiz ordered both men held on $50,000 bail, as well as a no-bail violation of probation for Ramey, who was convicted of a felony gun charge just last year. Mitchell also had an unlawful use of a weapon conviction on his record, according to prosecutors. And the two, again, now facing even more serious charges for their alleged crimes. Our armed citizen story of the day from Rome, New York, where police are investigating after an attempted home invasion apparently was thwarted by a neighbor who was armed with a shotgun. Yeah, how about this? From the Utica, New York Observer Dispatch, police responded on Sunday to reports of this home invasion. It was early Sunday morning. And during the investigation, police learned that a man wearing a facial covering and carrying a handgun entered an upstairs bedroom by removing a window air conditioning unit. Inside that bedroom, there's a man, a woman, and a 3-year-old child. The intruder allegedly hit the female resident several times in the head with the gun and then began searching the home. The Observer Dispatch says a neighbor became aware of the incident, retrieved a shotgun, and then entered the home. Once inside the house, the neighbor chased the man through the home, fired 1 shot in his direction. Police say they do not believe that the intruder was hit. The intruder actually fled the home through a second-story window. Then exited the home, found the neighbor, then left the home, found the suspect fleeing to a dark-colored SUV, fired 1 more shot at the suspect when the suspect turned towards the neighbor. The intruder, according to police, likely not hit, although the vehicle may have sustained damage. Again, police still investigating, but it appears that the quick thinking of that armed neighbor able to save that family there in Rome, New York. And finally today, we've got the story of a South Carolina sheriff's deputy who 1 year ago ended up saving the life of a newborn infant. And has now become her godfather. This is such a great story from WFLA.com. Berkeley County, actually a WCIV in Berkeley County, South Carolina. A year ago, this 12-day-old baby girl in this vehicle choking to death. Deputy William Kimbrough got the call. He arrived on scene. He was able to perform CPR, got the little girl breathing again, passed her off to medical personnel. But as WCIV says, that little girl did not leave Kimbrough's life. He said, when I met Riley, I saved her life. He got a chance to see her the other day. He said to give her a hug, a look over her shoulder. There's Miss Riley and her mom walking in. I said, you got to be kidding me. You surprised me. And they're like, yes, we did. Back on May 31st, Riley had her 1-year birthday. Deputy Kimbrough said she had her birthday. It was just phenomenal. We went to the birthday. It was great. And when Riley and her parents paid a recent visit to Deputy Kimbrough, they gave him a little scratch off as a gift. And he scratched off the little scratcher, and he said underneath the scratcher, it says, "Will you be my godfather?" And I just had this look on my face, and I just looked at Riley, who was sitting on her grandma's lap, and I said, absolutely, yes, absolutely. And my wife, he says, got the same card. So June 11th, 2019, Deputy Kimbrough saved little Riley's life. And over the weekend, Deputy Kimbrough got to become that little girl's godfather. He says, what was the reason I actually went down that street, Because there were 5, 6, 7 other streets that could have gone down. And as the saying goes, he says, God works in mysterious ways. Well, in Berkeley County, South Carolina, in the right place at the right time, and willing and able to do the right thing. Deputy William Kimbrough, we thank you, sir, for your good deed. That is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program today. Don't forget you can subscribe to Town Hall Media on YouTube or Bearing Arms Cam & Company on Apple Podcasts. That way you never miss one of these programs. And make sure you're checking in with BearingArms.com throughout the week for the latest, well, throughout the day and the week, for the latest Second Amendment news and information. We will have another VIP Gold live chat coming up on Wednesday of this week for our VIP Gold members. You can get more information about that at Bearing Arms or any of the Town Hall Media websites. Until we talk again, be safe, be well, be free, and we'll see you soon with another edition of Bearing Arms, Cam & Company.